in the choice between a world in which, wow, if we do something legally wrong, we could be hit with, tens of millions of dollars in judgments or something, or we could just, sweep it all under the rug and no one would ever know. I think a lot of corporate leaders choose option B. My name's Paul Bland. I'm at the law firm of Berger Montague. It's a firm that represents mostly plaintiffs, so individual consumers, workers, people injured, people cheated in various types of scams. I'm the co-chair of the appellate and complex briefing group at the law firm. For 27 years before that, I was at the nonprofit legal advocacy group Public Justice. And I'd been an appellate lawyer at Public Justice for 17 years, handling cases in court. And then the last 10 years, I was there as executive director. 10 years is a long time to be the head of an organization like that. And I thought it made sense for me to move on and do a different kind of work. So in my work, I particularly have a focus on consumer and worker rights cases where there's a forced arbitration clause. A big part of my work is trying to find the cases where you can beat the arbitration clauses and go ahead and have the case in court. The gist of the idea is that you're supposedly reaching an agreement that if the company does something wrong, they break the law, they cheat you, they break your contract, they violate some statute, you can't go to court, you can't have a jury. Instead, you're going to have a private decision maker, and the decision maker is an arbitrator. And the decisions of the arbitrators are almost impossible to get reviewed by a court. There's a Supreme Court decision that says even if they get the facts in a totally silly way, you still have to enforce it. Silly is not enough. There's a court decision that said that glaring errors of law are not enough to get an arbitrator's decision overturned. So these private judges, and then it's also a very secretive system. It's very hard to find out what arbitrators have done in previous cases. There's frequently gag orders in the contracts. And so you have these private judges who are mostly corporate lawyers deciding cases, and that's the end of the case. It's a fairly rigged system. Then for a lot of cases, they also have provisions that say that even if a company cheats, 10,000 people in the exact same way, they can't join together in a class action. They have to, each of the 10,000 people has to separately find their own lawyer, bring their own separate case in arbitration. If you look at every single case that the biggest arbitration company has handled in the last dozen years, and you compare it to a sample of same size of cases in court, that arbitrators are less likely to rule for a human being suing a corporation than a judge or a jury. And that if arbitrators rule for, if they do issue a ruling for an employee, for the worker, that it's tends to be in the range of 20 to 25% of what a jury or judge would have entered. It's literally impossible to buy a car in 99% of America unless you sign an arbitration clause. These arbitration clauses are more than half of all employment contracts. They're in nearly any contract putting someone into a nursing home. And while I think somewhat more people are starting to know about them, I think the vast majority of people in this country have no idea what this is and what it means. If you do a poll where you honestly describe how arbitration clauses work, what they mean, you get upwards of 90% of the public thinks that this shouldn't be allowed. But if you actually, somehow could wave a magic wand and Fox News would heavily explain this issue and talk about it for 20 minutes a night for a week, it would race through the U.S. Congress. It would become overwhelmingly popular overnight. If a company on their website, they're selling some good or service through a website, and if they really want people to be stuck with arbitration, it's fairly easy for them to do so. They can put language right up front that says if you click on this, you're essentially agreeing to the terms and conditions, which include an arbitration clause. And that's going to be enforced 99% of the time. And what happens is a lot of the people at companies who are involved in marketing want there to be as little information as there can be on the place where you click, because they want it to be as quickly as possible. They want you to make an impulse decision where you see the thing and you decide to buy it in 3 seconds. And if you wait 10 seconds to think about it, they think they're going to lose half the customers. So the lawyers know if you're trying to force people into arbitration, you need to say it pretty clearly. But a lot of times the business people don't want to do that. So there's a whole bunch of goods and services sold on the internet where you click on it to buy it. And then if you then went through and read through, 20,000 words, you would find that there's an arbitration clause, 2 days later, and nobody does that. And so there are a lot of courts that have said that where the sort of the business people who are trying to rush everything through won out over the lawyers, that they're not going to enforce the arbitration clause in that setting. And so that's been the issue where I think there's been the most victories for consumers, is where a company has just buried it so deeply. My job sometimes feels like I'm like an oncologist, where people are coming and saying, like, here's my kid, can you save them, kind of thing. And sometimes there's something that lets me help them get have a good shot. And there's a lot of times I look at it and it's like there's nothing I can think of to do. And so it really depends on the specifics of a case. And the truth is, the majority of the time, I'm not able to come up with a pathway around one of these things. There was this move over time where the Supreme Court was really interested in expanding the law favoring arbitration clauses, where the statute that they were relying on, this 1925 Federal Arbitration Act, the key part of the statute is only a single sentence. The main section of the statute is one sentence long. And the Supreme Court was inventing all these rules that started fitting into it. Then in the late 2010s, you had the Me Too movement and a recognition of what that meant. And there became a number of stories came to light of women, particularly, who had worked in workplaces where you had a predatory boss who was sexually harassing or assaulting women, and then they used the secrecy that comes with the arbitration clause to silence them. And it caused such a uproar that early in the 2020s, you had the Congress pass a law that says no more arbitration for sexual assault or sexual harassment cases. There was a CEO of a major fashion company who literally raped a series of women, and then they used the non-disclosure agreements and the arbitration clauses to silence them. And then he would just go and do it again. And the lawyers for the business and his enablers were like, oh, he's a fashion genius, we got to let him keep going. And he did this a number of times. And when that kind of story comes out, it's overwhelming. So a big factor in this was coming out of Fox News, Gretchen Carlson, who was famously harassed by Roger Ailes. And Gretchen Carlson started making a big issue out of arbitration clauses in sexual assault and sexual harassment cases. And because she coded as, someone very, very reliable to conservative voters, her involvement and her decision to take this on as a cause was hugely important. I give her a lot of credit in raising attention about this. I've been trying to raise attention about this for 25 years and wasn't able to reach nearly the audience that Gretchen Carlson was.
Here's the deal. Particularly in the last 5 years, banks, payday lenders, and others have just been able to completely break the law with impunity, and their customers really couldn't do anything about it. They've been hearing a lot from the industry about, wow, arbitration is just so great, and if we can't ban class actions, then we might abandon this wonderful thing of arbitration. It is a fairy tale. It is simply not true. Almost no consumers in America, it's a rounding error, it's a speck. It's hardly anybody is actually going to individual arbitration. It's just not happening. The market has spoke. They built it and no one came. Okay? It's not an accident, though. The point of these clauses are not written to say, hey, let's make it easier for people to hold us liable when we break the law. The point of these clauses are the opposite, and they've worked.
In general, in the United States, big corporations and powerful people can do all sorts of things and get away with them. And the jury trial is one time where powerful corporations actually have to have somebody look at the evidence it's a group of people who aren't particularly on one side or the other, who put aside a bunch of time, days, and sit there and listen to the evidence and decide what's right. And so jury trials in civil justice cases, cases where a company's broken some law, are incredibly important.